Welcome to Talk Trials. I'm your host, and today we are doing something a little different. We are stepping out of the sleek, polished courtrooms of the city and heading straight into the Mojave Desert.
Right into the heat.
Into the heat, the dust, and the silence of a town that quite literally is disappearing from the map.
It's a place that millions of people feel like they know intimately, even if they've never actually set foot in California. You mentioned Hinkley, or you mentioned Pacific Gas and Electric, and the cultural synapse just fires immediately. People see a movie poster. They see Julia Roberts holding a baby.
They see a check with a lot of zeros on.
A very big check.
Right. We were talking about Anderson v. Pacific Gas and Electric, the Erin Brockovich case. But here is the mission for today's deep dive. We need to shatter the Hollywood gloss.
Oh, absolutely.
Because in the movie, the credits roll when the plaintiffs win. The bad guy writes the check, the good guys smile, and justice is served with a nice bow on top.
But in the real world of toxic tort litigation, the check clearing is, it's rarely the end of the story. And frankly, the battle to get that check was far dirtier, far more technical, and much more ethically compromised than a 2-hour film could ever really show.
Exactly. We're going to dig into the actual legal machinery here. We aren't just going to say they use bad water. We're going to look at the chemistry of hexavalent chromium.
We have to.
We're going to dissect a very specific piece of scientific fraud involving a Chinese study that almost tanked the entire case.
A really shocking story.
And we're going to talk about slow violence, the way a legal settlement can sometimes accidentally finish off the very community it was supposed to save.
It's a story about PG&E, the defendant, a massive utility monopoly. And it's about 648 plaintiffs in Hinkley, California. But really, at the end of the day, it's a story about what happens when you turn a small desert town into a chemistry experiment for 30 years and then try to hide the results.
So let's set the scene properly. Hinkley, California, if you've ever driven from Los Angeles to Las Vegas, you've passed it.
You've driven right by it, probably without noticing.
It's high desert, scrub brush, intense sun, a lot of isolation.
It's a quiet agricultural community. Or, well, it was. People moved there for the space, the silence, the ability to raise animals. It's tight-knit. And right in the middle of this quiet life, in 1952, PG&E built the Hinkley compressor station.
Let's pause on the engineering for a second because this is so crucial to understanding the crime. Why does a gas company need a compressor station in the middle of nowhere?
It's all about physics. PG&E is moving natural gas through pipelines all the way from Texas and the Southwest up to the San Francisco Bay Area.
A huge distance.
A huge distance. And gas doesn't just flow on its own over that distance. It loses pressure because of friction against the pipe. So every so often you have to squeeze it, you have to compress it to shove it further down the line.
And anyone who remembers high school physics knows that when you compress a gas, you generate heat, a lot of it.
Massive amounts of heat. The gas gets incredibly hot. So before you can put it back into the pipe, you have to cool it down. If you don't, you risk damaging the pipeline itself. And this is where the cooling towers come in.
So you have these giant towers just cycling water through them to absorb the heat from the gas. It's a basic heat exchange system.
Correct. But here is the problem with running hot water through metal pipes, especially in the middle of the desert. Rust, corrosion.
Right.
If your cooling system rusts out, your plant shuts down. It's a huge problem. So back in the 1950s, the industry standard for stopping rust was a very specific chemical compound.
Hexavalent chromium.
Chromium-6.
Right. And, we need to get technical for just a moment because the distinction really matters here.
Okay.
Chromium is a naturally occurring element. You have chromium-3, which is actually an essential nutrient. Your body needs it for metabolism. It's in broccoli. It's in your multivitamins.
So chromium-3 is the good guy, the friendly chromium. It's the benign guy, yeah. But chromium-6, it's a different beast entirely. It's an oxidized form of the element. It is highly reactive, which is what makes it so good at its job. It binds to metal and creates this incredible protective shield against rust. It's cheap, and it works like a charm.
But biologically?
Biologically, it's a mutagen.
Meaning it literally alters your DNA.
Precisely. It can pass through cellular membranes very easily. Once it gets inside a cell, it gets reduced chemically, and that reaction releases energy and creates unstable molecules that just shred DNA. It is a known, potent human carcinogen. No debate about it.
So from 1952 all the way to 1966, PG&E is pumping the stuff through their cooling towers. Millions upon millions of gallons of water laced with chromium-6. The question is, where did all that water go when they were done with it?
And that is the 370 million gallon question.
Yeah.
They didn't treat it. They didn't put it in special tanks. They discharged this wastewater directly into unlined earthen ponds.
Just pits.
Just big pits dug into the desert floor.
370 million gallons. I'm trying to visualize that. That is an ocean of toxic water just sitting there in the dirt.
And, gravity does the rest. Because the ponds were unlined, the water didn't just stay there. It percolated down through the sandy soil until it hit the aquifer, the groundwater table.
Which is the town's drinking water.
It's everyone's drinking water. And once it's in the aquifer, it moves. It creates what they call a plume, a slow-moving underground river of poison that just spreads out under people's homes and farms.
But they didn't just dump it, right? The sources mentioned they were also spraying it.
This is one of the more horrific details. Yeah, sometimes the ponds would get too full. So to manage the volume, they would just spray the contaminated water up into the air to encourage evaporation.
You're kidding. So you're atomizing a known carcinogen.
Yes, you are creating a toxic mist that just drifts on the desert wind. It lands on the soil, on the crops people are growing, on the school playground, on the laundry that's hanging on the line. People were breathing it, and the soil was absorbing it from above and below.
Did the workers know? I mean, if I see a barrel labeled hexavalent chromium danger, I'm putting on a mask, at the very least.
But they didn't see that. PG&E used a trade name for it. They called it BETS 45.
BETS 45.
BETS 45. So if you were a worker at the Hinkley station, you just knew you had to add the BETS 45 to the water.
Yeah.
It sounds like an additive for your car engine, It completely obscured the lethality of what they were handling every single day.
Okay, so this goes on for 14 years, 1952 to 1966. When did PG&E realize they had messed up, that they had a real problem on their hands?
The internal documents show they knew almost immediately that the water was migrating. By 1965, their own records, their own testing, showed the groundwater was contaminated and exceeded the safety levels of the time. They knew the plume was moving toward their neighbors.
1965. Okay, everyone keep that date in mind. Because they didn't tell the state of California until when?
Not until 1987.
That is a 22-year gap. That is a generation. Children were born in Hinkley, they grew up, and they left home in the time it took PG&E to mention, by the way, the water is poison.
And even when they did report it in 87, it wasn't a confession. It was a strategy. This is where we see the legal maneuvering kick in almost immediately.
Yeah.
PG&E organized a meeting with the residents of Hinkley.
This is the famous town hall moment.
Right. They gathered everyone up and said, effectively, look, we found some trace elements in the water. It's not perfect, but it's safe. We just want to let you know because we're good neighbors.
Why do that? Why tell them at all if you've hidden it for over 20 years?
Because of the statute of limitations. In California law, you typically have 1 year to file a lawsuit from the moment you discover you've been injured or, and this is key, discover the cause of the injury.
So it's a trap, a legal trap.
It is a calculated trap. If PG&E tells the residents there is chromium in the water, and the residents believe PG&E when they say it's safe, they don't sue, they go home. But legally, the clock starts ticking. So if they wake up 5 years later and realize, wait a minute, this stuff gave me cancer, PG&E can walk into court and say, too bad. We told you about the chromium 5 years ago. You're time barred. Case dismissed.
That is incredibly cynical. They were trying to inoculate themselves against future liability by giving a very carefully worded half-truth.
It's a classic defense tactic.
Yeah.
We didn't hide it. We held a town hall. And it might have worked too. The residents trusted PG&E. I mean, many of them worked for PG&E. It was the biggest employer in the area.
So what broke the silence? How did this go from a quiet, cynical cover-up to one of the biggest lawsuits in history?
It started, incredibly, with a real estate file. In the early 90s, Erin Brockovich was working as a file clerk for an attorney named Ed Masry. She wasn't a lawyer. She was just organizing papers.
Right.
And she was looking at a file for a pro bono real estate case involving the Irving family.
PG&E was trying to buy the Irving's house.
Exactly. But inside this real estate file, Erin finds medical records, blood counts, pathology reports, doctor's notes.
Which makes zero sense. If I'm buying your house, I need to see the termite inspection, not your white blood cell count.
Exactly. That anomaly, that piece that didn't fit, it just triggered her curiosity. She started asking questions. She drove out to Hinkley, and she started seeing the pattern. PG&E was aggressively buying up properties near the plant. And the people living in those properties were incredibly sick.
What kind of sicknesses are we talking about? Was it one specific thing?
It wasn't just one thing. That's what was so scary. It was everything. Chronic nosebleeds that just wouldn't stop, respiratory failure, hysterectomies in young women in their 20s, tumors everywhere.
And not just in people, right?
No, the residents told these horrifying stories about their animals, chickens being covered in tumors, frogs dying in droves, and the water. The water coming out of the tap was sometimes described as just being green.
Green water, and yet they were told it was perfectly safe to drink.
So in 1993, Masri and Vicito filed the lawsuit. Anderson v. Pacific Gas and Electric. They sued for negligence, strict liability, and crucially, fraud. The core accusation was that PG&E not only failed to warn the residents, but that they actively concealed the danger.
And the contamination levels they eventually found were they were off the charts.
Completely. The maximum contaminant level, or MCL, for chromium-6 at the time was extremely low, around 0.05 to 0.1 parts per million.
Okay.
In Hinkley, right near the plant, they found levels peaking at 20 parts per million.
20, so hundreds of times the legal limit.
Hundreds and hundreds of times the limit. It's a massive dose. So you have the poison, you have the victims, you have the lawsuit. Now, usually this is where we would talk about jury selection. We talk about the opening arguments in a packed courtroom. But that didn't happen here.
This is such a critical point that the movie completely glosses over. This case never went to a traditional open jury trial. Why not?
It really comes down to judicial resources and, well, delay tactics. The presiding judge looked at this case, hundreds of plaintiffs, incredibly complex science, massive amounts of discovery, and he looked at his overcrowded court docket. He essentially told the plaintiff's lawyers, I can't hear this case for at least 5 years.
5 years? If you have stage 4 cancer, you don't have 5 years.
You don't have 5 months. The delay was a weapon for the defense. PG&E could wait. They have infinite money, infinite time. The plaintiffs were dying.
So what do you do?
The plaintiffs' attorneys had to make a really tough call. They agreed to binding arbitration.
Let's unpack private justice for a minute, because arbitration sounds like a boring procedural word, but it changes everything about a case like this.
It changes the entire texture of justice. It's a huge deal. Instead of a public judge and a jury of your peers, you hire private judges, usually retired judges, to hear the case.
You pay them.
You pay them. And the proceedings are largely private. There is no press gallery. There are no TV cameras.
And no jury.
That's the big one. Corporations generally love arbitration because juries are unpredictable and emotional. A jury looks at a sick child and gets angry. A retired judge looks at a statute and a toxicology report and, does the math. It effectively turns a moral crime into an administrative calculation.
And for the residents, this must have felt like another betrayal. They wanted their day in court. They wanted to look PG&E in the eye in public.
They felt completely disenfranchised. Many were discouraged from even attending the hearings. That felt like their suffering was being processed in some corporate back room, not in a court of law.
Okay, so we are in arbitration. The plaintiffs have to prove that the chromium-6 in the water caused their sickness. Now, I would assume this would be easy. Chromium-6 is a known carcinogen. The water was full of it, case closed. But PG&E fought this tooth and nail. What was their defense?
This is where we have to give the defense credit for a very sophisticated, albeit incredibly cynical, scientific strategy. They didn't deny the chromium was there. They couldn't. Instead, they denied it could hurt you if you drank it.
Wait. How can you possibly argue that drinking poison is safe?
Their argument was based on the threshold theory and the chemistry of the human stomach. They argued that, yes, chromium-6 is definitely carcinogenic if you inhale it, which is why welders and industrial workers get lung cancer from it. But they claim that the human stomach is a harsh, acidic environment.
Stomach acid.
Exactly. They argued that when you swallow water with chromium-6, your stomach acid chemically reduces it to chromium-3 before it can get into your bloodstream and do any damage.
The good chromium.
The good, harmless chromium. So their whole defense was, yes, the water was dirty, but your stomach neutralized it like a built-in water filter. Therefore, your cancer must be from something else. Bad genes, smoking, diet, bad luck.
That is actually a terrifyingly plausible argument if you don't know the science deeply. It sounds scientific.
It was the ingestion defense. And to win, the plaintiffs had to prove that ingestion does cause cancer. And this leads us to the darkest chapter of the legal battle, the whole story of the Zhang article.
This is the detective story inside the legal story. Let's dive deep here. Who is Dr. Zhang?
Dr. Jiandong Zhang. He was a Chinese medical officer in the Liaoning province. In 1987, he had published a study about a chromium plant there that had contaminated the drinking water of a specific village for years.
Okay, so a very similar scenario. And what did his 1987 study find?
He found a significant, undeniable spike in stomach cancer among the villagers drinking that water. It was a clear link. Drink chromium-6, get stomach cancer. This study was a complete disaster for PG&E. It directly contradicted their stomach acid neutralizes everything defense.
So the existing science was totally against them.
It was, until 1997. Suddenly, right in the middle of the litigation, a new article appears. It purports to be a follow-up or an update to Dr. Zhang's original 1987 work. And miraculously, this new paper concludes that the cancer rates in those villages were not significantly elevated.
It reversed the findings.
It completely reversed the original findings.
So now PG&E can walk into court and say, look, even the guy who wrote the original paper now says he was wrong. There is no link.
Exactly. It became the cornerstone of their scientific defense. But the plaintiffs' lawyers, they smelled a rat. This was just too convenient. So they started digging into who paid for this update. And they found a trail leading to a consulting firm called ChemRisk.
ChemRisk. The name itself sounds a little ominous.
They were scientific consultants, and they were hired by PG&E specifically for this litigation. And through a series of depositions, the truth started to leak out. We need to talk about the deposition of a man named Tony Ye. He was a scientist at ChemRisk.
We have the transcript of that deposition, and it is painful to read. He's just squirming.
It's a masterclass innovation. The plaintiff's lawyers just grilling him, asking how this 1997 article came to be. And it turns out ChemRisk had hired Dr. Zhang. They paid him, but didn't just pay him to translate his old data. They helped him analyze it.
Helped him, I see.
They engaged in blatant statistical manipulation. Here's how they did it. The original 1987 study focused specifically on the village with the contaminated water. The new study, it diluted the data. They took the cancer statistics from the contaminated village and averaged them with data from uncontaminated neighboring villages.
I see. So if a village A has 100 cancer cases and village B and C have 0, if you average them all together, the rate suddenly looks low. You hide the cancer cluster.
You completely wash out the cancer cluster with healthy data. It's statistical fraud, plain and simple, but it gets so much worse.
How?
When they published this reanalysis in a peer-reviewed medical journal, they stripped the names of the ChemRisk scientists from the byline. It was published under Dr. Zhang's name alone. And nowhere in the article did it state that the study was funded by PG&E or ChemRisk or their lawyers.
They presented it as independent academic research, when in reality it was a defense exhibit disguised as science.
Correct. And I want to look at the deposition of Brent Kerger, another ChemRisk principal. The plaintiff's attorney asks him point blank about the billing. Who paid for this work? And Kerger has to admit, on the record, under oath, that the hours spent clarifying Dr. Zhang's data were billed directly to Haight, Brown & Bonesteel.
PG&E's law firm.
PG&E's lawyers. And there were even documents found internally with a little star symbol on them, a literal asterisk.
The ChemRisk star.
The lawyers asked, what is this star? Tony tried to dodge it. He said, I don't recall. I don't know. But eventually it was established that the star indicated documents that are part of the ChemRisk project file for PG&E. It connected the raw data manipulation directly to the published article.
I want to read a specific exchange from Tony's deposition because the squirming is just audible.
Please.
As if reading, question. Did you tell Dr. Zhang that PG&E was taking the position in litigation that chromium did not cause cancer in humans by oral ingestion? And Ye's answer, I don't recall that. Question. Did you tell Dr. Zhang that the purpose of this study was to help PG&E in a lawsuit? His answer, I don't believe so.
I don't recall. The refuge of the guilty. But the paper trail, the billing records, the stars, it destroyed them. They proved that the defense wasn't just interpreting science, they were actively manufacturing it.
And that revelation had to have shattered the credibility of PG&E's experts, right? If you lie about the Chinese study, why should we trust you about the stomach acid theory?
Exactly. It poisoned their entire case.
So the science defense is crumbling. And right around this time, the statute of limitations defense also takes a fatal hit. We talked about that 1966 memo earlier.
The smoking gun. This was a document from 1966 found deep in the PG&E archives. It was a memo from corporate headquarters in San Francisco to the station manager at Hinkley. And it was explicit.
What did it say?
It acknowledged the water was contaminated with chromium. It acknowledged it was poisonous. And it gave a direct order. Do not discuss this with the neighbors.
That is the key, isn't it? Do not discuss.
That phrase is worth hundreds of millions of dollars because legally, that is fraudulent concealment. And the law says that if a defendant actively hides their crime, they cannot use the statute of limitations as a shield. The clock is told. It's paused. It never started running.
So by proving PG&E lied and actively hid the truth in 1966, the plaintiffs proved they had the right to sue in 1993.
Exactly. It opened the floodgates. It meant PG&E was on the hook, not just for the cleanup and medical costs, but for punitive damages.
Yeah.
Punishment money. Big money.
So now PG&E is cornered, their science is exposed as fraudulent, the statute of limitations defense is dead, but they still have one card left to play: causation.
Right.
Even if the water is toxic, even if they lied, can you prove this specific woman's breast cancer came from the water? Because women get breast cancer in clean towns too.
This is the hardest hurdle in any toxic tort case. It's called background rates. The defense argues, look, cancer is a tragedy, but it's common. You can't definitively pin this specific case on us.
So how did the plaintiffs overcome that?
They used a dose-response map. It was visually devastating. Imagine a map of Hinkley. You overlay the known plume of contamination, the red zone where the chromium is highest. Then you put a pin on the map for every plaintiff's illness.
And what did it look like?
It looked like a bullseye. The closer you live to the compressor station, the more severe and the more numerous the illnesses. Inside the red zone, that's where you had the rare tumors, the multiple cancers in one family, the hysterectomies. As you moved out from the center of the plume, the symptoms became milder.
That correlation.
That dose response, as they call it, is very, very hard to explain away as just coincidence.
So faced with the fraudulent science being exposed, the statute defense dead, and this ghost response map staring them in the face, PG&E finally blinked.
They had to. If this went to a verdict with the evidence of a cover-up, the punitive damages could have been in the billions. They had to cut their losses. So in 1996, they agreed to settle.
For $333 million.
At the time, it was the largest settlement ever paid for a direct action lawsuit in U.S. history. It made headlines all over the world.
And this is where the movie ends. Hugs, tears, a fat check, justice is served. But we need to look at what happened next. Because the distribution of that money was, well, it was chaotic.
Chaotic is a very polite word for it. Remember, this is arbitration. There was no public judgment saying Mrs. Smith gets $5 million for her cancer. It was a lump sum given to the lawyers to distribute based on a private, complex formula.
A secret formula.
A secret formula. And this caused massive infighting and confusion in the community. First, the residents waited 6 long months for the checks to even arrive. And when they finally did, the amount seemed completely arbitrary.
I found an example of the Gonzalez family in the source material. It's just heartbreaking. You have a father who had his colon removed, a massive life-altering surgery. He received $100,000.
Which, after you take out legal fees and 40 years of past and future medical bills, it's not a fortune.
Not at all. But then you have his children. One child had some skin problems and got $200,000, double what his father got. And another child who also had skin problems got $0.
$0. Why? We don't really know. Maybe the medical records for that child were incomplete. Maybe the formula weighted age differently. But because of the secrecy and the non-disclosure agreements, the residents couldn't compare notes. They couldn't understand it. It just bred suspicion.
Neighbors who had fought side by side started looking at each other sideways. Why did you get more than me? Was your sickness worse than mine?
It shattered the community solidarity that had won the case in the first place.
It's unbelievable.
It really is. The settlement solved the legal problem, but it didn't heal the town. In fact, you could argue it accelerated its destruction. And this brings us to this concept of slow violence.
This is a term from the scholar Rob Nixon. It's a fascinating idea. We usually think of violence as something fast, a gunshot, a car crash, an explosion.
Right. Slow violence is violence that occurs gradually and out of sight. It's a violence of delayed destruction, of attrition. And Hinkley is the perfect tragic example. The contamination didn't just magically stop when the check cleared.
So the plume was still moving, even after the settlement.
Oh, yes. In the 2010s, 15 years after the settlement, new reports showed the plume was still migrating, still spreading. The cleanup efforts were struggling. So, faced with the threat of even more lawsuits from new victims, PG&E changed tactics. They started a buyout program.
They just offered to buy everyone's land.
If you lived on the edge of the plume, or anywhere near it, PG&E would come to you with an offer to buy your house. And many people, just tired of the fear of the tainted water, they sold. But here's what PG&E did next. They bulldozed the houses.
They flattened them, wiped them off the earth.
Yes, and this created what sociologists call the checkerboard effect. Imagine living on a street. Your neighbor to the left sells. His house is crushed. Now you live next to a dirt lot with a chain link fence around it. Then the neighbor across the street sells. Their house is crushed.
It's a psychological siege. You're living in a graveyard of homes, watching your town disappear one house at a time.
Exactly. It destroys the social fabric. The population plummeted. And without people, the institutions that make a town, they die. The elementary school closed in 2013.
And that's the death knell for any small town.
It is. No school means no young families will ever move in. Then the only market closed. The post office closed. The only gas station in town shut its doors in 2015. Hinkley became a ghost town.
There is such a bitter, profound irony here. The lawsuit was supposed to save the community. The whole point was, stop poisoning us so we can live here safely. But the ultimate result of the justice they received was that the community ceased to exist.
The slow violence of the contamination, combined with the corporate strategy of buyouts, erased the town more effectively than the pollution alone ever could have. The check cleared, but the town died.
I want to tie up one last loose end before we get to our final assessment. The science. That fraudulent Zhang article that PG&E used, did that ever get fixed? Did the truth come out?
It took a long time, but yes, it did. The detailed investigation by the plaintiffs' lawyers and subsequent inquiries eventually forced the journal that published it to issue a full retraction.
On what grounds?
They cited the failure to disclose the massive financial conflict of interest, that it was funded by a defendant in active litigation.
So the scientific record was eventually cleansed.
It was, and that matters, So it's a small victory, but it's an important one. It proved that litigation-driven science that's bought and paid for to win a lawsuit, can be caught and exposed. It's a victory for scientific integrity, even if it came years too late to help the people of Hinkley during their actual trial.
All right, we are entering the final segment of our deep dive. We call this the 10th chair. This is where we step back from the legal weeds and ask the big overarching question.
In a quick disclaimer, what we're about to discuss is our own reasoned assessment for informational and discussion purposes only. We are commentators, not your lawyers. This is not legal advice.
So Anderson v. PG&E, the Erin Brockovich case, was justice served.
It's such a split decision. I'll start with the yes column. That $333 million settlement was a thunderclap that echoed through corporate America. It forced every corporate board in the country to look at their environmental liabilities in a new, much more expensive light.
It put a price on negligence, a very high price.
It did, and it vindicated the residents. It was a public acknowledgement that they weren't crazy, they weren't hysterical, they were being poisoned, and they were right.
That's the win, a big one.
But then you have the loss column. The arbitration system created a kind of two-tiered justice that left victims confused, suspicious, and in some cases, feeling shortchanged. The secrecy of it all protected PG&E's reputation for far too long. And ultimately, the legal system completely failed to stop the slow violence that erased the town.
The law can give you money for a house, but it can't give you back your home. It can't give you back your town.
Exactly. Justice in our system is almost always reactive. It's designed to clean up the mess after the damage is already done. It is very, very bad at preventing the damage from happening in the first place.
And that leads us to our final provocative thought for you, the listener. When we see a headline about a massive corporate settlement, we tend to think, case closed. We think the problem is solved. Justice is done. But we have to ask ourselves, if a settlement checks a box on a corporate balance sheet, but it wipes a town completely off the map, was the problem actually solved, or did we just put a price tag on the destruction of a community?
That is the uncomfortable question Hinkley leaves us with.
That is going to do it for this deep dive from Talk Trials. We hope you look at the headlines and maybe your water bill a little differently now. Thanks for listening.
Stay curious.